Hey, good morning. Good morning. Okay, much better. See, all right. On behalf of my colleagues, Judges Murray and Kelly, welcome to the Michigan Court of Appeals. This is day one of our Detroit case call. This is panel three. Um, I'll give you my usual spiel for the benefit of the lawyers. While we've read your briefs, we've had reports from our staff on all the cases, so we're well familiar with the facts. You don't need to belabor the facts. You can just cut to the right to the most decisive legal issues and tell us as succinctly as possible why you think you should prevail in your appeal today. In cases involving minor children or protected persons, please just initials only, no full names. All of these proceedings are being digitally recorded and will be uploaded to YouTube within the next 24 hours. With that, I think I can call the first item of the day, and the lawyers appear to be ready to go. It's item one, docket number 376810, Lance Richard Winter versus Terry Nicole Brock.
Good morning, Your Honors.
Morning.
May it please the court. My name is Terry Brock, appearing on behalf of appellant respondent mother, pro se. This appeal presents pure question of law on an undisputed record. No material fact is in dispute, and every critical fact admitted by appellee in his own filings under oath and through counsel affirms most of my allegations. The Oakland County Circuit Court enforced Arizona custody orders without performing the conformity analysis this court's published precedent requires. It enforced orders obtained by a person who is not a legal parent in a state that was not the home state under the UCCJEA through documented material misrepresentations, and the result was arrest of the sole legal parent and the removal of her child from the state of Michigan through precipient enforcement. Appellant should prevail with a vacator with an immediate return of the minor child because every controlling authority, including NOC, authored by Your Honor Godola and Your Honor Murray, Ashley Rose, which I believe Godola authored, or Murray. And
Jealous. Go ahead.
Hatcher, the UCCJA, the PKPA 7221006, the U.S. Constitution, and they all say the same thing. A putative father with no legal parentage cannot use a court that had no jurisdiction to seize a child from the sole legal parent. When measured against the law's stated purpose, what actually occurred to appellant and the minor child constitutes what has been described as a grave injustice. The trial court failed to apply 6 independent statutory safeguards, and that failure weaponized the system to, again, arrest the sole legal parent for exercising lawful custody in the state of Michigan, and a forcible seizure across state lines of the minor child, and an arrest predicated on accumulated false police reports, orders obtained by, again, a legal stranger through documented misrepresentations. Your Honors, there are no published Michigan opinions addressing the weaponization of interstate custody proceedings through fabricated filings by a parent, at least not one that I found. There is no published opinion applying 1208 to a pattern of fabrication designed to unlawfully seize a child. This is not an abstract jurisdictional technicality. The enforcement orders turn the statutes upside down and in turn invert it against the proper jurisdiction and invert it against the sole parent. Person with no legal rights was given the child, and the person with sole legal custody by operational law was arrested. If Winter appellee had done this without a court order, it would be a felony under 750-350. The trial court's void enforcement order cannot transform felony conduct into lawful custody. When a person who knowingly procures void orders through fraud and then uses it to seize a child, they cannot claim that void order as a shield. And the issues for standards of review are subject matter jurisdiction under the UCCJA, statutory interpretation, whether sister state exercised jurisdiction in substantial conformity, and my argument is that they did not, whether standing presents a defect in the orders as well, and whether an order is void ab initio. All standards that are reviewed de novo by this court. as well as abuse of discretion, where clear legal error of law outside of the range of reasonable and principal outcomes arise, and failure to exercise discretion. I do want to ask if there are any questions in regard to the briefs that I could address before I go forward.
Any questions? No.
As I asserted exhaustively or ad nauseum, as the court puts it, first, Eppley was not a legal parent. He lacked standing to invoke jurisdiction in any state. And second, Michigan was the child's home state. And in Arizona, it never acquired jurisdiction under the UCCJEA or the PKPA. And the timeline was asserted through material evidence within the briefs and the appendix, where relocation commenced about 10 weeks after the minor child was born to Michigan on June 8th, 2022, and remained in Michigan as a lawful resident under appellant's sole legal care. Received Michigan benefits, family events, holidays.
Didn't our court already say that Arizona was the home state?
Yes, and that is a part of my argument in Appeal
Well, I feel like to
3677.
argue against that. That was back in what, 2023 or 4?
Yes.
2023. You can't argue against it now.
Well, 367477 was the case number, and I do have a question about whether or not if that appellate argument was a vacator as opposed to a declination. When appellee filed an appeal to vacate the June 29, 2023 jurisdiction order, he was a putative father, and I believe under MCR 3205, he would not have been considered an aggrieved party. Also, that vacator was October 5th, 2023, while he was still not a legal parent to the minor child.
But the problem is you can't, in a later proceeding, challenge the prior decision of the court. That your chance to challenge it was then, and if you didn't like what was done back then, you'd go to the Michigan Supreme Court. And once that is concluded, you're done. You can't just keep going back and attacking a prior order or judgment of a court. That's a fundamental principle, not only here, but probably in all the states.
I understand that. And from that, that was based on the date of filing in Michigan, which was February 16, 2023. If you also do the 6-month look back at a police filing on May 17, 2023, the minor child was still a Michigan resident 6 months prior to May 17, 2023. And according to the UCCJEA 6-month look back, that vacator was not a declination, but a vacator. And it also cited, it looks as if the minor child spent more time in Michigan in November 2023 and moving forward. Also, the vacator of 367477 was procured through material misrepresentations. And so during that time, appellant mother was represented by counsel, and a lot of evidence was not placed in the record. And I know that this is a fact-finding court. And with that, the accusations of absconding, when appellee filed that the mother absconded on May 17th or May 18th, 2023, he was actually on the phone with the mother while the mother and child were traveling to South America. And so that was a material misrepresentation. He also stated that the mother was residing in Arizona leading up to the child's birth. Partially true, because the mother did most of her prenatal care within the state of Michigan up until November 2021. That wasn't provided in that case as well. Also, appellee gave two contrasting narratives between Michigan and Arizona. He told Michigan that the minor child had been abandoned in Arizona and that the mother, appellant, had not cared for the minor child, when in fact, appellee had no care and no history of care with the child whatsoever. He told Arizona that appellant mother had resided in the state of Arizona and traveled to Michigan as a temporary absence, when the temporary absences were just appellant mother traveling across the U.S. with the minor child solely in her care. And appellant mother never opposed that she traveled with a minor child, but using the number of days that the mother spent in Michigan versus the narrative that a appellee gave with the mother allegedly abandoning the child, receiving all medical care in Arizona when in fact the minor child was on MDHHS benefits dating back to August of 2023 up until the child was seized. The minor child had dental care in Michigan, MDHHS nutritionist care in Michigan in August 23, mothers groups with the minor child in August 2023, all was in Michigan in July of 2023, December 2023, January, February, March, and moving forward. And I do understand that there's a void order doctrine which applies, and I do have a question about whether or not the appellee was considered a aggrieved party in the appeal and when he filed in August 24th, 2023. And 5 days later, Michigan and Arizona had a UCCJEA conference where Michigan affirmed jurisdiction. Again, I do understand under the UCCJEA, in order for a person to
Why are you continuing to talk about this?
You keep trying to relitigate the prior determination of this court. We are absolutely without power to come to a different conclusion than a previous panel of this court did. So we really don't want to hear any more about the decision of this court that Arizona was the home state and has jurisdiction. Now, this is about the registration of the Arizona judgment in Michigan. If you have anything to say about that ruling of the trial court, the decision to register the judgment, that's all we are here to consider.
Yes, so the enforcement of the Arizona judgment, like I said, there was no analysis. There was no meritorious claims in the order. There was no statutory interpretations. There was no order stating whether or not Arizona exercised jurisdiction in substantial conformity. There was also no merits on the fraud-based arguments that I brought to the trial court. Because again, I was not a resident of Arizona with a minor child. The minor child was on Michigan benefits. And when he filed on May 17, 2023, dating back 6-month look back was November of 2022. And so I do understand that 367477, that vacator exists and it dismissed that case, but it was at the time of the filing. And if at the time of my filing in February 16th, 2023 was not deemed proper, when he filed in May of 2023, it still was 6 months after the minor child was a resident receiving medical care in the state of Michigan. And then the fraud on the court, Arizona's orders, which the trial court refused to address, states that I was working physically in the state of Arizona as a medical supply sales manager. That is a job that appellant mother has never had. She's never worked in the state of Arizona. She's never worked for the person who provided the affidavit that she was working in the state of Arizona, David Murphy. It is completely untrue. And to allow orders to stand with material fact that is provable on government documents from the IRS, from MDHHS, and then to also have the child seized not under the guise of the enforcement, but appellee told the law enforcement that appellant mother's rights were terminated to seize the child. They did not investigate or thoroughly review any orders. And also, appellee's counsel in trial court proceedings admitted on December 11, 2025, that appellee was a legal stranger, had no AOP, no determination of parentage, no DNA test at the time, and no order of affiliation. There's still no order of affiliation that exists in any court. Arizona did not do an order of affiliation. They did not do a parentage hearing. They asserted jurisdiction in December of 2023 and then requested a DNA test, but on the basis that they believed that appellant mother was working physically within the state of Arizona, when she absolutely was not. And I do have a question about the appeal from the vacator from 2023. Under Gerard 437, Mich 231, He was a non-parent, not a aggrieved party. That is arguably a void ab initio appeal. Hatcher 443, Mish 426, Clement 254, Mish App 387, and void judgments can be collaterally attacked in any court at any time. They were also procured by fraud, which I've asserted under 2612C1C. And if orders are procured by fraud, which I argued that they were, there's a no time bar as well. For Renti 504, Mish 1, fraud on the court vitiates regardless of time. And regard Hague 412, Mish 532, a vacator is not equal to a declination. So I would like clarification on if a vacator and a dismissal of a case actually is a declination under the UCCJEA, or is it just a timing, an act of timing as far as the filing of the case? Because the minor child and appellate mother were absolutely residents of the state of Michigan of June 8, 2022. And I find it concerning that a plea could write briefs and appeals and trial court documents that are presented to the court with no factual undertone basis and so many material misrepresentations that are provably false.
Ms. Brock, I think we have a reasonable grasp of your arguments, understanding that you will have some time left for brief rebuttal. Is there anything else that you need, feel compelled to tell us at this time?
Yes, I would just like to touch base on the unjustifiable conduct under the UCCJEA. And there are about 14 violations in 5 categories.
We don't need to hear 14 violations in 5 categories.
Okay. I will wait for rebuttal.
Okay, thank you.
Good morning, Your Honors. Jordan Ayler Smith on behalf of the appellee father in this matter. Your Honors are 100% correct as to the majority of appellant mother's arguments. They essentially compromise a collateral attack on this court's October 2023 determination that Arizona was the proper forum to determine the issues of child custody and the related issues to that. The parties actually litigated this for a year in Arizona for the course of 2024. Mother actually stipulated to paternity in Arizona in February of 2024. So the only question that is properly before this court is whether the trial court erred in enforcing the December 2024 custody order that was issued by the Arizona court. And the answer to that question is a resounding no. There was no error in the trial court's order whatsoever. While there is a lack of jurisdiction defense under MCL 722.3074, which is the enforcement statute under the UCCJEA, that ground is only available if the judgment had not been properly registered beforehand. Father registered the Arizona court order with the trial court in Michigan in February of 2025. So the only question for the trial court was, is the order that is asking to be enforced, has it been vacated, stayed, or modified in some way by the issuing court with appropriate jurisdiction, which was Arizona in this case? And again, the answer to that question is no. The trial court here fully complied with the requirements of the UCCJEA before enforcing the Arizona custody order. And that's really the end of it. And I have many other points that I could give to Your Honors, but I don't think it's necessary. I think Your Honors have a very good handle on this case, and I would invite any questions. Otherwise, I will simply ask that this court affirm.
Any questions? No, I don't have any either.
Thank you.
Thank you, Ms. Ayler Smith. Ms. Brock, this is your opportunity for a brief rebuttal if you have any.
I understand that jurisdiction is a dispositive principle, and subject matters jurisdiction cannot be stipulated, waived, conferred by consent, or altered by subsequent proceedings. In regard of Hatcher 443, Mish 426, Bowie v. Arter 441, Mish 23, and that single principle goes against also the fabricated residency narrative. The core legal argument was that that drove every proceeding from May 2023 in Arizona is that appellant did not live in Michigan or did not live in Arizona with the minor child. The minor child resides solely in the state of Michigan. And in C.S. Alexander, a court cannot exercise jurisdiction with respect to a putative father before his parentage is legally recognized. In May of 2023, no ALP, no DNA test, no filiation. October 23, no ALP, no DNA test, no filiation. Appellant mother refiled a new paternity case, which is controlling under Ashley Rose, that the mother and child files in the form and venue in which they reside. And as of October 2023, mother and child resided in Michigan for at least 16 months by that
Did
time.
you stipulate to paternity in Arizona and the Arizona proceedings as your opposing counsel just represented to the court?
I did not stipulate willingly. I was told that if I tried to leave the state of Arizona without filing a stipulation of an agreement, that the judge would have entered a warrant for my arrest.
Told by whom?
My attorney, Deshaun Poland, told me that Judge Wu of Arizona said that if I tried to leave the state of Arizona without signing the stipulated agreement,
So the answer to my question is yes, you did stipulate.
yes, but
Okay.
jurisdiction cannot be stipulated, waived, or conferred by consent.
That's not what I asked.
Yeah.
Thank you.
And that stipulation, according to the record, was done 2 days after the stipulation was signed on February 22nd. And paternity was still not adjudicated by the time that that initial temporary custody order came out of Arizona. And so if parentage must exist at the time of commencement, May of 2023 versus February 2024, it does not meet the statutory guidelines for enforcement or registration or meeting the conformity of the UCCJEA. And so standing at commencement is the requirement, and that was not the case. And it is, from what I understand, to be black letter law. And the statutory framework under 717 says no legal rights under order affiliation standing under the Paternity Act is fused to subject matter jurisdiction, and it is not waivable. And so if that's the case, it should override MCR 3204 when they conflict, because the Paternity Act's venue provisions represent a legislatively declared principle of public policy, which Ashley Rose versus May, Judge Godola, I believe you authored that. And under 722-1006, so custody vests in the unwed mother. We were never married. I did not reside in the state of Arizona during the time of any commencement, and neither did the minor child. And if you review the material evidence from the IRS, from MDHS in Michigan, all the affidavits, the doctor's appointments, the letters from Henry Ford Health System, even in January of 2023, it all affirms domicile, residence, life, family, things in the state of Michigan. Also, I do believe that the recipe bypass mechanism that was used for enforcement was an abuse of discretion as well. On July 16th, appellee and counsel filed a recipe motion. In less than 24 hours, there was an enforcement hearing. Appellant mother reached out to the court, filed a motion for adjournment in order to get counsel. She was not able to get counsel because the mother and child were leaving the state that day. And so it's the same pattern of behavior from when he filed on May 18, 2023, accusing the mother of absconding, knowing that she was traveling, that followed through to that July 2025 recipe order. Appellee knew mother and child were traveling and then filed an emergency motion to essentially thwart or circumvent Michigan jurisdiction to make mother appear as if she were doing something nefarious when she was not.
And I'm going to cut you off there because you've gone well beyond the permitted scope of rebuttal argument, which is to respond only to what your opposing counsel just argued. And you're really just re-arguing, rehashing, repeating your principal argument, which frankly has nothing to do with this appeal. So unless my colleagues have questions for you, I think we've heard enough.
Okay,
Okay,
thank you.
thank you. Case is submitted. And just for clarification, Ms. Ayler-Smith, we won't be hearing from you on item 9, is that right?
Correct, Your Honor. I
Okay.
have weighed my argument
All
on
right,
that.
very good. Just
Thank
wanted to
you.
confirm. Thank you. Thanks for appearing. All right, with that, I'll call the next item. It is item number 2, docket number 370852, People of the State of Michigan versus Robert Lee Freeman, Jr.
Morning, Your Honor.
Morning.
Susan Walsh on behalf of Robert Freeman. Uh, I'll just be brief. I know this has been thoroughly briefed. And so I'll just hit a few things that I thought were important looking through the briefs. As to the first issue, there were no signs of intoxication. And the officer didn't have any belief that Mr. Freeman was intoxicated. So I really think that, he should have been given a ticket and that should have been the end of it. I think a view of the video shows that they really wanted to investigate him. And that was the purpose of the traffic stop. As far as the roadside search, can't really see the whole thing on the videos, and so you don't know if maybe the underwear will pull down at certain points. It was a pretty busy area. There were cars driving by, and
Police officers seem to me to do as much as they could to block anything from being seen, and it barely you see worse people walking down the streets outside this building than you did with your client.
I understand.
You know what I mean? I mean, there wasn't much
Yes.
shown.
I grew up with raising kids in the 90s.
Yeah, I mean.
So I understand. I just feel that there needed to be a little more discretion, and, it would be great for this court to set some guidelines in that area. I think the big issue in this case is the sentencing. I was here for the Remy case, which I know is still pending with this court. I did do some updating of the cases that I cited in my brief, and the People versus Killian was remanded for resentencing. And then I think the other cases I listed were not as egregious as this case within Galt. The trial court was merely asking for clarification and doesn't lecture until after imposing the sentence. And then in People versus Spencer, this court found that the court's questions kept the defendant talking instead of shutting him down, which was what happened in this case. And, here the trial court's interruptions, interrogations, lectures, they all prevented him from having a reasonable and meaningful opportunity to speak. And because of the number of interruptions, it was plain error, and that the Michigan Supreme Court has stated in Petty that this automatically entitles a defendant to resentencing. I also believe, because of so many cases like this with Judge Lane, that it really needs to be remanded in front to a different judge. So I set all that reasoning out in my brief, unless the court has any
Can
other
I just
questions.
ask something on that last point? Because I was thinking about that too. And, what you want is the judge not to say anything, right?
During elocution?
Yeah, right.
Yes.
So it goes back to Judge Lane, and if we send it back and say, stop interrupting people, why does it matter if it's her or somebody else? It's just giving him the right of allocution. It's probably not going to make a difference to anybody, but you never know, I guess. But it just seems like, given the difficulty in sending it to a new judge anyway, under the general standards, what difference does it make this just for this purpose?
Well, I don't think it would be real difficult to send it back to a different judge, because it's not a difficult case. It's straightforward. I think it was possession with intent.
I don't mean
to
it by
deliver.
that. I mean, I'm just
Yeah.
saying the standard to switch judges
Okay.
is difficult.
Well,
to meet.
High bar.
Yeah.
Well,
And
If there's an order saying this judge has a history of hectoring defendants during their chance to elocute, she has to allow him to do it. And hope that doesn't mean you take that.
Yeah, I mean, Judge Lane has been on the bench for a really long time, and this seems that things are escalating in this area with her. And I just feel that it shows that there could be an appearance of impartiality against defendants like Mr. Freeman, and just to be safe and get the matter taken care of, I think it should go back to a different judge.
Okay, anything else?
No.
All right, you'll have time for a rebuttal.
May it please the court, Stephen Gilliott on behalf of Appellee. I guess I would like to start out the initial stop. It went very quickly. I think it was Miss Stone who authored the brief, did the timing. It was less than 2 minutes before he gave consent to search. And he's ordered out of the car. The car has dark tinted windows. Everything is on video, including when the female deputy arrives kind of during the search. She stays back. She stays on the sidewalk, and her body cam shows no buttocks whatsoever. And the court is correct. The 3 male officers shielded him, and he had on four pairs of shorts. The outer shorts, the red ones were pulled down, but that left the green, the black, and the white underwear, which is where the methamphetamine was sewed into a pocket. So as it relates to how that went down, I think the officers acted very reasonably. Regarding the sentence, I'd like to point out that the recommended sentence by the Department of Corrections was 17 to 50. Judge Lane didn't do anything. She didn't upward depart from what their recommendation was.
The minimum sentence was at the top of the guidelines, as I recall. Is
Yeah,
that correct?
I think the guidelines went a couple years more than that, but it was on the higher end of being 17 years.
Maybe not at the very top.
Correct.
I see.
Yes.
Okay.
Yeah, it was up there, but that was what.
Within guidelines.
Yes,
Okay.
within guideline. And I thought it was appropriate to mention that that is what the Department of Corrections recommended. Judge Lane didn't do anything different as it relates to that. And I think a lot of that is based upon the more than extensive criminal record, as well as the quantity of what was going on with respect to the methamphetamine. It certainly did not go ideal. I think what we had here was a situation where Mr. Freeman started to give reasons, which he's obviously entitled to do, and Judge Lane was trying to clarify. There was the point that came up where about working, and I don't want to say he's blaming other individuals or outside, but he indicated that he was having difficulty, and I think she did press him a little bit about factory jobs are readily available in our community. And so her area, certainly she did push him. And I think the record there does speak for itself. It would have been easy to just let him give his version of events and then maybe ask some clarification questions if she had any, and it didn't quite go that well. It did seem to, at the end, it ended kind of strange where she did at the end ask him if he had anything else, and he did not. So,
Anything else for us?
no.
Okay, Ms. Walsh, any rebuttal? Mm-hmm.
I've been doing this job for almost 25 years and, it said right in the PSI, Mr. Freeman's parents were murdered when he was 15 months old. So if anyone, deserved a little mercy or at least a little time to allocute, I think Mr. Freeman would be that man. And, he was just trying to explain that it was tough for a convicted felon to find work. And I think that what opposing counsel brought up really supports my argument that it should be a different judge. So
Okay,
thanks.
thank you very much. Appreciate your arguments. Thank you for appearing here today. The case is submitted. Okay, that brings us to item number 3, docket number 373059. People of the State of Michigan versus Missiera Monique Jones.
Okay, Susan Walsh on behalf of Miss Sierra Jones. Again, I think the matter's thoroughly briefed. There's a siren outside. I'll let that go away. And I just wanted to point out that defense counsel never brought the motion to suppress prior to the trial. It was brought in the middle of trial. I think that's ineffective. You're supposed to bring motions during the pretrial motion period, and he did not do that. And then when the trial court gave the ruling denying the motion, the trial court noted that the prosecutor already stated that the gun would be admitted during the trial. And also the prosecutor argued that the motion was untimely. And I think that, had the motion been brought, even though there was other evidence, I think it would have just put I think it would have been granted because she didn't give consent for seizure of the gun. And then that would have helped Ms. Jones in her case from that point forward. So she was prejudiced in that matter. And then as far as the 911 call, this is kind of a sore point for me, is that we have all this great digital capability, but everything's just erased after 90 days. And so it doesn't help. And so I think even, especially with 911 calls, if you could just make a transcript of the call, if there had been a police report filed in conjunction with that 911 call, then at least the parties would have that. And without doing something like that, I think it's just bad faith on the part of prosecutor, and it really hurts the defendants in their case, and that because of that, there should be an adverse inference instruction. So unless the court has any other questions, other than that, I would rest on my pleadings.
Any questions? No, you have time for rebuttal. Thank you.
Morning, Your Honors. Matt Fillmore from the Oakland County Prosecutor's Office on behalf of the people.
I have a question about the gun
Sure.
before you even start. I think it's the case that defendant consented to the search of the vehicle. The officer finds the weapon, I think, in the console
Right.
of the
Right.
car, and then he seizes it or keeps it. The argument of your opposing counsel seems to be that the officer didn't have the right to seize the gun once found. I mean, that he might have had to have a warrant to seize it. It's evidence of an alleged crime at that point. So I think that's the authority under which the officer operated. Is that enough? Can he keep the gun without having a warrant to search for?
Yeah, in this case, there was probable cause to seize the gun. We've got evidence from the victim who called in, said the defendant pointed the gun at her, and then gave the license plate number, which brought the police to the defendant. When the police were talking to the defendant, she admitted that she was part of this road rage or road altercation, and she denied pointing the gun, but she admitted that she had a gun. So I think once the police officer was able to confirm that there was a gun, the gun was in the car with all this other evidence about her pointing the gun, the account from the victim that amounted to probable cause, which falls under the automobile exception that the officer has the ability.
I admitted I was hurt. I didn't see what the harm was.
Correct. Yeah,
Told that he didn't have to report what he was going to do. She said, I have done. Seizing a gun has nothing to do with whether or not you should maybe the gun.
correct. And
I didn't see that harm.
yeah, my argument is that the officer did have authority to seize, and he had the authority to search and to seize the gun. But even if he didn't, the gun was admitted as evidence at trial, but it didn't matter because the defendant admitted she had a gun. She admitted it came down to whether the victim's testimony that there was she was pointing the gun, and then just the fact that defendant admitted she had a gun, she kept it in her car was enough. The actual physical gun wasn't necessary to prove the prosecution's case. On the second issue, the Arizona versus Youngblood issue, there's been no showing of bad faith by the defense. The recording of the 911 call was routinely destroyed after 90 days. This is not something done nefariously to destroy the evidence, exculpatory evidence. It was the police were looking for the defendant, weren't able to find her within, it took them a few months to find her. By that point, the 911 call had been deleted, and there was, yeah, by that point it was gone, and it wasn't a purposeful thing by the police to do that. And in any case, you can see from the evidence or from the testimony that they testified a little bit about the 911 call, where the victim testified that she gave the defendant's license plate number during the 911 call, and then the officer testified that he was dispatched on a felonious assault. So obviously, the victim would have said something about a gun being waved around. Otherwise, the officer would have said he was dispatched on a felonious assault. So there's no indication that there's anything exculpatory in that recording, especially before it was deleted. Any questions?
Policy in fact of the 90 days.
I can't answer that, but I have had other cases where recordings have been deleted within, I think it was 90 days. So I don't know
I
how,
wonder if when they instituted that policy, if storage was an issue, where now clouds and what have you can be even for longer than that.
yeah, I can't answer that, but I know it does cost money to even store things in the cloud. And so it could very well be a monetary issue.
All right, thank you.
Thank you.
Any rebuttal?
Just real brief, I think that the important part of my issue is the timing of the motion to suppress, that it should have been done before the during the pretrial period, and it would have put my client in a better position. And that is not anything that's difficult for a defense counsel to do. I mean, these.
His explanation that he didn't know he couldn't imagine why they would have moved to enter it for the reasons we're talking about. And as soon as he found out that they intended to do it, he filed a motion.
Well, I mean, you have to anticipate things in advance and go through the file and look for any possible issues that there could be to have a strong case and a good position for plea bargaining and negotiations. So I think that it should have
Also
been.
give someone an idea to say, maybe it is a good idea to bring in that gun, but they weren't even thinking about it. Really. So sometimes your anticipation can backfire.
I appreciate that argument, but I do think that it should have been brought up prior to trial. And also, we're talking about the digital capabilities. Here, you can get a search warrant just waiting in the street. You don't even have to go in front of a magistrate. So they could have gotten a search warrant when she didn't give them consent to seize the lawfully owned gun, and that also the prosecutor had her license plate from the beginning, so I don't know why it was difficult for them to track her down. So unless the court has any other questions,
Any other questions?
rest on my pleadings, and I'm gonna stay right here.
Don't
Nice.
move. You're on a roll, Ms. Walsh.
Yeah.
That case is submitted.
Susan Walsh Day at the Court of Appeals.
Yeah,
That's
I know, it's
right.
never happened to me
I
before.
know. I don't know that I've ever seen one lawyer argue 3 consecutive cases, which, the third one being item 4, docket number 373-353, and Mr. Gilead is reappearing. People of the State of Michigan versus Bobby Villareal. Ms. Walsh for the third
Okay.
and hopefully the final time, unless we
Right.
impress you. Yeah, there are. Thank you. Yeah,
Oh,
thank
right,
you
right.
very much.
There are
I
two
had that
cases.
noted
That's one
here
of
and
my
I forgot
issues.
to
Yeah.
appreciate that.
Okay,
The second case is docket number 373-354. Also, people of the State of Michigan versus Bobby Villareal, and they are consolidated for the purposes of our arguments here today.
all right, I think my most interesting issue of the day, saved till last, the issue of the search incident to the traffic stop, orchestrated by the police, and it is thoroughly set forth in the briefs, the issues are, and all the case law and everything, but I just wanted to focus in on, first we know that Mr. Villareal told one of the officers that he had smoked marijuana recently. And I would also note that I have other cases, more recent cases, and the canines are no longer trained for marijuana. And I find that interesting. The prosecutor relies on the Wren case, which is distinguishable because in that case, there was no GPS tracker and no canine, like just waiting in the wings. And also the Haney case is distinguishable because here the police knew in advance that it was like a traveling traffic violation they had created with this Bobby. I can't remember her last name. So what the plaintiff does is separate all the I think it's, I loved how the prosecutor just summed it all up in his argument, how they created this whole stop and a trap for these defendants. And the prosecutor tries to separate out each one and say, well, this was okay, and this was okay, and this was okay. But that's not the argument. The argument is that the whole thing, totality of the circumstances, violated my client's constitutional rights.
Well, we do look at the stop at the very least separately, and it was a good traffic stop, wasn't it?
I don't know, because
Well, the vehicle was uninsured and unregistered. So how was it
Right.
not? They ran it through lean. They see the license plate. This is the same car that was, stopped for the same reason not long before. Still unregistered, still uninsured.
right,
I
well,
mean,
they knew that it would.
You and I would
that
get
was-
pulled over if that
Right,
happened, and
right.
the
But
the
he-
police would have a right to do so, wouldn't
He
they?
wasn't the driver, he was a passenger in the car, and the police had set up that stop. They knew that she was their informant. They knew that she was going to be driving without insurance and updated plates. So they knew that they had that all set. Then they tracked where they were going. And then they had the canine there waiting. And so it was all sewn up for them. And I think that violates the Rodriguez case. You're not even allowed to extend a traffic stop to get a canine, but to put up this whole, trap, I think goes even farther than that. So I think that it's unconstitutional. And I would also, note that in the Armstrong case, now A warrantless search must be based on probable cause, and the smell of marijuana is insufficient to support probable cause. Here we have evidence that marijuana was around the car. We know that the dogs can pick up residual odor. And so I think that negates the probable cause, and that the whole search was unconstitutional. So
And you couldn't cross-examine the dog.
right.
What did you
Right.
smell?
Maybe someday we'll have technology to do that, but not yet. So unless the court has any other
Any
questions.
questions? Okay.
The
Sirens.
The sirens are
Yeah,
back.
remember, they're back
Thank you.
again. All right, high
They're
high
coming to get
crime
you if
area.
You don't like their processes.
Right. All right,
Oh.
Mr. Gilliard,
Thank you, Your Honors. I would like to
we need
clar-
your appearance first.
Yes, Stephen Gilliard on behalf of Appellee. I would like to clarify one point. I think from the facts of the case, and the reason that the police got the search warrant to put on the car, and they had done that a couple of days before, that demonstrates that the driver was not an informant. She was clearly not working with the police. She was probably more the target of the investigation, because a couple of days earlier, Mr. Villareal is with her as well. And that's when he gave the name of his, I believe it was his brother. And they didn't write her. They left the vehicle. I'm not sure if they impounded it, but the vehicle was clearly left. She was driven home. And that's when the tracker was put on the vehicle that she was driving. So I think it's the record, while it doesn't come out and say she was not an informant, I think it's very clear she was not working in any manner with the police.
Your point being, they wouldn't have had to go through that whole rigmarole. She would have said, hey,
Absolutely.
just
She
come
would-
over to my house and put the
Yep,
tracker on the
and
car.
I'll tell you where we're going, and we're going to be heading to Flint this day to likely re-up on drugs. So as the vehicle's coming back, that's when, and it's very clear, this was a pretext stop, which is lawful, but the stop itself was lawful because of the status of the car and the fact that she's driving it. And then we also have the situation where Mr. Villareal is with her again. And only here we have a situation where the coat in which the methamphetamine is found also contains Mr. Villareal's wallet, his identification. There was a green bandana that also was present. And while it's not clear it was the same bandana that was on Mr. Villareal's identification, they were both green bandanas. The other thing I would like to just point out is I think that the defense attorney, David Kelly, in this case, did an excellent job, that he was not ineffective in that the jury did not convict Mr. Villareal of possession with intent to deliver. They convicted him of the less serious of possession, which he admitted during his interview that he possessed the coke, that he possessed the methamphetamine. So I think to say that defense counsel was ineffective, I believe he was highly effective in that he saved Mr. Villareal in the end of likely a substantial prison term.
Mr. Gilliard, can you refresh my recollection with respect to the canine? Was the canine right there at the time?
Canine
They didn't have
was-
to summon the canine.
Correct. The canine was there, and this was a border patrol canine that on occasion does assist the drug task force. And it is not marijuana trained, because obviously marijuana is still legal federally.
Yeah, I think it is an interesting
Yeah.
argument made by defense counsel that the dog is trained to detect the odor of what in Michigan anyway is a legal
Correct.
substance. Do you have any thoughts
Well,
on that?
here, I mean, clearly the dog is also trained to alert for methamphetamine. And the dog alerted, and lo and behold, a decent quantity of methamphetamine was there. There was no evidence other than Mr. Villareal's statement that earlier he had smoked marijuana. But that also kind of leads into, dogs also do false alert. It doesn't mean that there's not probable cause to search. Dogs do make false alerts. This just so happened to hit in the area where the methamphetamine was. So while we can't ask the dog, what were you smelling? It's highly likely that at least in part, the dog was smelling the methamphetamine that was retrieved from the jacket.
Any other questions for counsel?
This has nothing to do with the issue, just my own curiosity. When you say it's an ICE dog, do they rent it out, or, I mean, how does that work?
So Border Patrol, they will assist because in our county, we have so many of them with the Canadian border. So we have an excess of ICE agents and Border Patrol individuals, and they do have some dogs. And they do frequently assist in narcotics work, such as exactly what happened here.
All right, thank you. Any rebuttal, Ms. Walsh?
Okay, as far as the driver of the vehicle, there was something, I think the record really supports that there was something going on, because she wasn't even arrested after she was pulled over in that car with the drugs right next to her. They were in arm's reach of everybody in that car. And I don't think my client ever said that he possessed meth. I think he said that he had smoked meth that day. So he never admitted anything about that was those were his drugs. And so, and also I would note that the canines can alert on even like if someone smoked marijuana and then touched the door of the car, that would be enough for a dog trained on marijuana to alert. So, anyway, unless the court has any other questions,
Any other questions?
anxiously await to see what you guys decide.
Thank
So-
you. The
Oh, I'm not
case,
supposed to say you guys.
these cases
Sorry,
are
Your
submitted.
honors decide.
The court.
Thank you.
Yes,
Thank you.
yeah, right. Yeah, I usually, but you're, Ms. Walsh, you're excused for the day. Thank you. All right. You bet. Thank you, Mr. Gilliard. That brings us to item 5, docket number 373596, estate of William Jones versus Boulevard Temple Care Center. And counsel for the appellant, Mr. Oliver, we can take your appearance. You're permitted only to answer any questions we may have, but Mr. Oliver is not present. All right. Counsel for appellee, we'll hear from you.
Morning, Your Honors. Adam Pradko on behalf of Defendant Boulevard, and without opposition, we will be brief. Really, we just want to expand on one of our arguments and touch on a couple other points very quickly. First is the trial court properly struck the testimony of Nurse Portillo Sanchez. I think it's obvious from the record that she did not have a sufficient basis for her opinions to be qualified as an expert. We want to expand on, so even if the court disagrees with the decision to strike the testimony, affirmance is still required. Not every error of fact or error of law requires automatic reversal. In a similar context to this case in Craig v. Oakwood Hospital, the Supreme Court made clear that an error in decision on an expert testimony doesn't require automatic reversal. Rather, if the defendant would still be entitled to summary disposition if proposed testimony were left in, then the appellate court should affirm the trial court's ruling. And we think that's what should control here. And Craig, the dispositive issue is causation. Here we have more of a factual issue. Really, the testimony was insufficient to show duty or breach. Nurse Portillo Sanchez was unable to point to any single Boulevard employee who was negligent, and that on its own is dispositive. The other point was that what she called breaches for failure to document. As we pointed out in our brief, it's not a viable theory of causation in medical malpractice case. Documentation doesn't cause any kind of physical injury. So for these reasons, her testimony is insufficient. Because the trial court reached the correct overall outcome by granting summary disposition, this decision to strike testimony can't possibly have fallen outside the range of reasonable principled outcomes. So this provides another alternative basis for the court to affirm the trial court's decision. And then just 2 quick points. We'd like to reiterate our argument that plaintiffs abandoned the issue, that they should be allowed to add a new expert on remand. They didn't raise it in their statement of the question presented, and their argument, it's really only a couple sentences. There's no citation to authority, and that's abandonment. And then finally, just very briefly, if the court does disagree with us in a remand, we would just ask that the remand be limited to experts that were already on the witness list. They didn't really ask to go beyond that, and so we don't think it'd be proper for the court to go on the relief that it's on the trial court. So unless there's questions.
Any questions for counsel? I don't think we have any. Very good. Thank you for appearing. Appreciate your arguments. And the case is submitted.
No.
Sorry. All right. I should have asked up front. All right, Ms. Gostock.
Good morning, Your Honors. Catherine Gossick on behalf of Defendant Henry Ford Hospital. I just want to bring up one more point, that plaintiff on appeal did not actually argue that the testimony by the nursing expert is reliable. There's no argument regarding MRE 702, no going through the factors of the Daubert standard. Their only argument was we should have had the opportunity at trial to elicit more testimony from her. Plaintiff could have done that during the deposition. In fact, they did on 2 occasions, but did not get testimony they wanted. They don't get a second bite at the apple. And unless this court has any questions.
Questions for Ms. Gostock? All right, my apologies. All right, thank you very much. Now the case is submitted. And that will bring us to the last item on our 10 a.m. call. Item 6, docket number 375401. Brooklyn Outdoor LLC versus Catherine Vanderbush.
Good morning, Your Honors. May it please the court, Jan Rubenstein, on behalf of appellant plaintiff Brooklyn Outdoor LLC. I'd like to reserve just a few moments for rebuttal in this matter. Your Honors, this appeal is very straightforward. In the prior appeal, this court noticed a deficiency and omission in both the plaintiff's summary disposition briefing as well as the trial court's analysis. And that omission was relative to whether or not there was a reasonable competitive interest that Brooklyn Outdoor had in maintaining this non-compete. There was no challenge at the trial court level or at the appellate court level to scope or duration of the non-compete. It was just this issue of whether or not there was a reasonable competitive interest. This court, in compliance with its standards and obligations, resolved that issue. And this court very specifically indicated, bear with me for a moment. Under these circumstances, plaintiff possessed a reasonable competitive interest in this information and the goodwill it had built with its clients. Consequently, the non-compete clause is not unreasonable for lack of a competitive business interest. We therefore conclude that defendants have not demonstrated that the non-compete provision is unenforceable. The court further went on after talking about the allegations of violations to indicate we agree that these are acts violate section 3B of the non-compete agreement.
And then it went back down and the trial court dismissed the case.
Yeah, dismissed the case, and procedurally how is interesting.
How's it possible?
We filed a motion for discovery because my client had learned that there was a new company that had violated the non-compete that was opened by the same person, Ms. Vanderbush. So it went back down. We had a motion for discovery. Now, mind you, Your Honors, there was no renotice or reprecipice of the summary disposition that had at that point been filed 5 years earlier. I believe it was 4 to 5 years earlier, in front of a different judge, by the way, and it was decided by a different judge at the trial court level. So this court made their determination, and this court allowed the case to go back, specifically indicating on remand, the trial court should consider whether plaintiff has met its burden of showing that the non-compete clause is enforceable. And if so, to what extent under the circumstances, we do not retain jurisdiction.
What do you take that to mean, by the way?
I take that to be an invitation for the appellee to challenge the reasonableness. I do believe.
Like the scope and duration and all that?
Scope and duration. The non-compete, I'm sorry, the reasonable competitive interest issue is conclusively decided. I mean, that's not ambiguous language. It's very clear, at least in my reading of it. So the competitive interest issue is clear. The court found that the appellees had failed to demonstrate that it was unreasonable. So I agree, Judge Murray, the issue remained that they could challenge scope and duration. They never had before. They certainly had every opportunity, and I read this court sending it back to the trial court to litigate this to a final result eventually. Mind you, this is a 2019 case. Judge Barry at the trial court level, on this motion for discovery, Mr. Frank, who, by the way, is an excellent lawyer, argued to Judge Barry that, well, nothing new has happened. And to that point, he was correct. Nothing new had happened. The Court of Appeals had reversed and remanded based on what it had read in its de novo standard, and counsel acknowledged nothing new had happened. But counsel then instructed Judge Barry, and Judge Barry listened to counsel, that all you're supposed to do here, Judge, because it wasn't briefed sufficiently previously 5 years ago, is now you have to dismiss the case. Well, that's antithetical to what the Court of Appeals actually did. The Court of Appeals specifically could have affirmed the decision of the trial court and specifically elected not to, and also specifically elected to address this very issue of the reasonable competitive interest. So the law of the case doctrine was violated when Judge Barry ruled in that way. Now, additionally, I think it's important to note the context of the motion for discovery. Obviously, we had filed a motion for discovery, and with that, Mr. Frank, the defendants at that time, had filed a response to that motion. Now, in their brief to this court, and as I was reviewing it last night, the argument was made, well, no, Judge Barry was sufficiently briefed because we brought up this issue of the reasonable competitive interest in our response to the discovery motion. Now, mind you, and as all this court knows, the court rules preclude any reply briefs or supplemental briefing unless specifically allowed. So the plaintiff, the appellant in this case, had no opportunity to address that allegation, nor was it really at issue in the case. There had been no dispositive motions. There had been no motions, no litigation, and no filings whatsoever at that point other than our motion simply for discovery. The trial court was very clearly directed on what to do. The trial court did not do so. The trial court in this case created a waiver that simply didn't exist. Found in some way that this argument had somehow been waived and ignored this court's very clear and strict instructions, unambiguous. Waiver cannot be revived. And in fact,
I don't know that it's completely unambiguous. I think the directive of this court was for the trial court to determine whether your client had met its burden, which is past tense, not can meet. I mean, we'd be in a much different, and you'd be in a much stronger position had this court previously said, we're remanding specifically for the trial court to conduct a hearing to determine whether or not your client can meet its burden.
you're right.
Very clear. That's not what this court said, unfortunately. It was past tense, had met at some point in the past. So it's not unambiguous, I don't think.
That's fair. That's a fair point, but we can't disregard that this court on this very narrow issue of the competitive interest made a clear finding and resolved that issue without ambiguity, at least from my reading of it. And I respect this honorable court if you disagree with me, but the court
I may
found.
not disagree with you on the ultimate, issue on the decisive issue, but only with respect to whether or not this court's previous directive and remanding it to Judge Barry was unambiguous. I'm not sure. it
And that's a very
was.
interesting point. I agree with you, because the court indicates that we find there is a reasonable competitive interest, but in the instruction section, the court does say to discover whether plaintiff has met its burden. Now, I don't want to read into, I'm
Go
sorry,
ahead. No, go ahead. I think.
I don't want to read into what this honorable court was thinking at the time or
Right.
had intended to happen, but it appears to me that the court intended for some proceedings to occur, for some evaluation and analysis to occur. Now, interestingly, and this is very unique, the procedure here. This idea that the summary disposition motion that had already been decided by the trial court, and I believe it was 2022, reversed by this court, and I believe it was 2024, and now we go back on remand, and somehow, some way, the trial court found that that motion, and only that motion specifically, was still pending. It was not. There had been no petition for application to the Michigan Supreme Court. There had been no request for reconsideration of this court's prior decision. So the statements regarding the reasonable competitive interest and the conclusions, those stand. But interestingly, if we agree with the trial court here, then we have to say that anything filed in the over 2 years of litigation, all of those motions are still fair game, because nothing had been reprecipied, renoticed. There had been no opportunity to address any specific issue. And even in the hearing, and you've got the transcript of it, it was fairly short. There was a narrative by Mr. Frank about what he believed the trial court was supposed to do. And he believed that the trial court was supposed to simply affirm because, well, with the lack of information, because Mr. Frank and the trial court didn't seem to notice the language where the trial court definitively decided that there was a reasonable competitive interest. So, Your Honors, I don't want to belabor the point. I mean, as I said in the beginning, it's very straightforward. I do also want to indicate that the refusal to reopen discovery was also reversible error. Now, that's obviously under a different standard of review. That would be an abuse of process standard. But that was a violation. Let me back up just for a minute, because I'm losing my words. How this happened is very interesting. The trial court in its transcript indicated that I'm granting summary disposition that had been decided already years ago and reversed already years ago. But the order that came out simply said, we're dismissing the case. It didn't say I'm granting summary disposition. So there are two different standards as it relates to an involuntary dismissal, as well as a summary disposition grant, or deny for that matter. And then we have, of course, the issue of discovery, which is an abusive process. So I think I'm belaboring this point and maybe talking a little bit in circles. So if the panel has any other questions, I just want to close with the fact that this court already rejected affirmation by reversing this case previously under these same facts and the same analysis. The trial court applied the wrong procedural lens that this post-remand case was mandated to then go grant the summary disposition that had already been reversed. And third, it's just inconsistent with the facts of this case, facts of reversal and not affirmance.
I want to go back to the procedural posture. This is something you addressed in which Judge Barry, looked back to determine whether or not your client had met its burden of proof. I think you indicated that was in the context of a discovery motion, not the summary disposition. So can you just briefly walk through that?
Sure. Summary disposition motions, and there were multiple summary dispositions filed on both sides, were in 2020, and that was in case in front. It started with Judge Lita Popke. It went to Judge David Groner, and eventually after remand, we went to Judge Barry.
Right.
So Judge Barry appears and on the record doesn't indicate that she ever actually reviewed those motions. I don't know if she did or didn't, but she doesn't indicate as much. And in fact, some of her statements on the record do seem to be unsure about even what the content of those motions were. So Judge Barry did listen to esteemed counsel, Mr. Frank, like I said, an excellent attorney, and she complied with his interpretation of what this was and his very partial interpretation of what this was. So therefore, procedurally, we never had, and by the way, had there been a renotice of hearing on that summary disposition, we would have all been prepared to go have an argument. And while I still think I would have had a valid argument here, it would have been weaker, because you could say to me, well, you had your opportunity to address that issue. It was noticed, notice was given, process was proper, everything was done properly. But in this context, We asked for discovery and the judge said, I'm going to grant summary disposition that's already been decided 5 years ago. It just doesn't work. Thank
Thank
you.
you. You'll have time for it though. Thank you.
May it please the court, Jonathan Frank for Ms. Vanderbush. I'll address Judge Murray's question right off the bat. How is this possible? So the procedure before Judge Groner had been a filing of a motion for summary disposition by the defendants on the non-compete claim. So when Judge Groner issued his summary disposition decision, he didn't address at all the argument that the plaintiff hadn't met its burden of demonstrating any facts to show the reasonableness of the non-compete. It's a blank slate in Judge Groner's opinion. We had filed the motion for summary disposition. We argued it. In response to our motion, there was no opposition in the brief that plaintiff filed. The brief opposing my summary disposition was silent on plaintiff's attempt to meet their burden.
Well, this is the question I was asking your opposing counsel because I thought he was suggesting that this failure to meet the burden came up in the context of a discovery motion. You're saying it was on the summary disposition.
Summary disposition. There was no.
That was my recollection, sir.
Yes, our appendix 1, 2, and 3 are the summary disposition briefs. Our brief lays out the argument that it's the plaintiff's burden to show reasonableness of a non-compete. There's nothing in the opposition. Our reply brief notes the fact that there's nothing in the opposition.
So your point is, why should they get a second bite at the apple on remand if they didn't respond to your motion for summary disposition?
That's exactly the point.
But my retort to that is that the opinion from this court changed everything.
So we need to dissect because it's somewhat confusing, to be honest, what this court.
It's confusing enough where Judge Barry should not have just said, I'm just dismissing it.
So if we take if we take the prior panel's remand order in the final paragraph, literally, I think as Judge Goodall said, as well as what the court said on page 11, which is defendants challenged the enforceability of the agreement, arguing the plaintiff had no protectable competitive business interest. Plaintiff did not respond to this argument, and the trial court did not address it.
Was this error?
Which was error. So
It was error.
Judge Groner mistakenly left a hole in his opinion.
Right. Well, but don't, unlike you, I'm not representing a client. I look at the whole opinion and I got it right here where there's quotes about our court saying, quote, the non-compete clause is not unreasonable for lack of a competitive business interest.
So I'm looking at page 12. There's a full paragraph this court wrote. We have to look at the context of that. There was no cross motion for summary disposition filed by the plaintiff.
That all very well could be true. All I know is that paragraph and maybe others is crystal clear that the court is making, as counsel said, the court even said that your client violated section 3B or something like that.
So I guess the issue is, where do we draw the line between the dicta that is that and what the court ordered on remand? Because to be honest with you, Judge.
I will suggest to you that the trial court cannot ignore what was said in that opinion and she didn't even talk about it.
So whether she talked about it or not, there's no procedural mechanism for this court to have ordered, and the court didn't order, anything that tracks what the court wrote in the middle of page 12. For example.
But wait, you could, okay, go ahead.
If I could, so.
You're not going to change my mind, but go ahead.
That's okay. I understand. I appreciate that. We've talked before on other cases. I know.
Usually much more open-minded.
Yeah, right. Well, if you read this stuff and you've been doing it a long time, you come to your conclusions.
So let me just address that because I think the court should look at this and wonder how the prior panel got to the point of stating, we therefore conclude that defendants have not demonstrated that the non-compete is unenforceable, and in the prior sentence say it is not unreasonable when that was not an issue presented to the prior panel. There was no motion on behalf of the plaintiff to make that ruling, and nor did they make it to Judge Groner.
How is it though? And it's right. It's just what the chief judge said too. It's ambiguous, the opinion, when in conjunction with a remand order. But given that the court had said there was a competitive business interest to protect, that your client, did violate section 3B, and then remands it for it to be resolved as to whether the agreement was reasonable, the only thing left is to resolve, and this is more of a question than the statement, the duration and geographic scope. Isn't that the only thing that's left if there's a competitive business interest?
I disagree with you, Your Honor. I understand your point of view. And
That's a question I'm asking you. What else would be left? What else is involved in a reasonableness determination if you accept the court saying that there was a competitive business interest?
all of it, Your Honor, because there was no evidence. This court, in its opinion, there's no evidence to support any of what the court wrote in paragraph, in some middle of page 12. It wasn't in their brief. I can't tell. For example, the court says there was goodwill. They never made the argument there was goodwill.
But even if that's the case, and I'm not doubting, I'm not saying you're not correct. It's there. It's in the opinion. I don't know why they wrote it. I don't think I was on the panel, but it's there. And it's stated in a conclusion about these two things. And so you know.
And again,
That's why, as counsel said, when you went back down, you read Precipe summary disposition and say, don't worry about the Court of Appeals opinion, it's dicta. And here's why there's no competitive business interest. And here's why there's not reasonable in these other factors.
Right.
And you resolve it instead of what happened in this case.
Yes, I appreciate that. I may or may not change your mind. I want to just make it clear what my argument is. And then, the idea is, as much as anything, Judge Barry reads the remand directive. It says, as Judge Goodall pointed out, past tense, did they meet their burden? Judge Barry looks at the record. She says they didn't even respond to the motion for summary disposition. As a result, no, they didn't meet their burden. She says, I've complied. Now, she does that in the context of a discovery motion. So procedurally, one wonders how she did it. However, they filed a motion to reconsider that to Judge Barry. They laid out the whole issue. Judge Barry, you shouldn't have done it in a discovery motion. Here's the evidence that was presented, and she denied the motion to reconsider. So we've included in our brief suggestion from this court that says you don't have to worry about the procedure there, whether Judge Barry used the wrong forum in the first go round when she did it in a discovery motion, because of the motion to reconsider kind of cures that problem. By the point of the motion to reconsider, everything was in front of her, the procedure, the substance, and she decides again, case dismissed. Her ruling on the record is dismissed because it's not raised in the opposition brief. So if you send it back with the directive as you sent it before, and it's still not in the opposition to summary disposition, remember, procedurally, we're not at a trial. We're at the point that I filed a motion for summary disposition. It was granted, and now will it be granted again on remand? It'll still be up to her to look at a motion for summary disposition. And the court didn't say you can expand the record to the plaintiffs. So in theory, what happens now is she says exactly the same thing she said before, which is my record is motion for summary disposition, nothing in the opposition.
Hard to imagine that's what this court intended when the case first ended here.
I wish it was clearer. I think we all wish it was clearer, because the court did say plaintiff did not respond to the argument and the trial court did not address it, which was error. So there's a blank in the record of plaintiff's opposition.
That is one way to interpret it, that this was just, you need to check the box. That was the directive of the prior panel.
Right.
That's one way to look at it.
What I really don't want to have happen is for Judge Barry to read anything this court wrote and think, well, I'm now bound by this apparent decision that wasn't even part of the appeal.
Here's the problem I think I see with your argument. This panel could have made that determination the first time around. If that's all it was, this court could have, in the first appeal, done exactly what Judge Barry did, which is, because it's all in the record, so it was before the court, they never responded to the motion for summary disposition. So you lose. So why send it back?
I don't know.
Yeah.
I mean, that's the issue with the remand, the conclusion. It says
I know what the answer is.
whether plaintiff has met its burden.
Please.
The answer is That's chief judge. You contact judges Letica, Cameron, and Redford and say, what were you thinking?
That's right.
What were you
We'll pull
thinking?
the pan.
Right.
I mean,
Of course,
I
we can't
honestly,
do that.
I
but
know,
We'd like to, but we
I
can't.
appreciate, of course, and we would all appreciate that because there's this ambiguity in it. What I really don't want to have happen is Judge Barry to think her hands are tied behind her back in favor of Brooklyn Outdoor on a remand where she looks at the language and says, well, I guess I
I've
have no
already
choice.
said, right.
I've
yeah.
already
But
decided.
that's
the
law of
court's
the
already.
case, or
I mean,
right.
that can't be true because there wasn't even an issue presented where this court could have said, we rule in favor of Brooklyn Outdoor dispositively.
Yeah.
If we assume that's true, we have to assume the remainder of the paragraph there in the middle of 12 is somewhat inartfully drafted because it does seem to suggest, if you read it literally, that this court has already commanded a result against me.
I don't think that can be the case either. And I think we might all agree on that piece, at least. I don't want to speak for Judge Murray, but
Okay.
or Judge Keller
All right.
on that particular point.
All right. I think I've laid out that completely,
Yes.
probably overly completely, but I'll move on. There's a couple other issues. One, we raised the issue in our brief, which is there's an alternate basis. If the court is now taking a summary disposition ruling and deciding what to do with it because there were gaps, we raised the issue that as the first breaching party, the employer or the independent contractee is not in a position to enforce a non-compete. And the underlying fact is already resolved to the point of payment being made to Ms. Vanderbush was that they didn't pay her commissions. That's undisputed. It's a judgment in her favor for a lot of money. So our argument is, and you can decide this on the record, which is as an alternative reason to affirm the motion for summary disposition grant in the first go round, is that Brooklyn Outdoor has no business enforcing a non-compete against someone that it didn't pay $175,000 to. And that's the first breaching rule. And it's been applied not in Michigan, but elsewhere to a non-compete. It just doesn't make sense in any way of any legal or fair or equitable context to let an employer who didn't pay that much money to also say, and when you leave, you can't compete with me. And that's what this court could decide to support the decision. The last issue I'll raise has to do with the discovery motion itself, because that's included in the appeal. The discovery motion, if the court reads it, is way after the fact. This court didn't allow any new evidence to be generated. And the discovery motion itself is a plain vanilla discovery motion that says, here's the court rule, and we should reopen discovery. So just on that basis, Judge Barry was right to say, well, why are we reopening discovery? The case was set to go to trial. There's been summary disposition motions. We're not reopening discovery on a case. But that aside, what Brooklyn Outdoor did when it presented to this court was add arguments and evidence that weren't even presented to Judge Barry in the plain vanilla motion that it filed. It now created new record that it's impermissible. We argued it in our brief. I think exhibits J, K, and L of the appellant's brief are brand new. They didn't even present them to Judge Barry. So there's no basis to reverse what Judge Barry did in terms of closing and maintaining the closure of discovery. The case was set, hermetically sealed. It was 3 weeks from trial by the time Judge Groner finally issued his decision. So.
Any other questions? All right, thank you.
Okay.
Counsel?
Thank you. Try to be brief again, but I just wanted to respond to a couple of the arguments by counsel. First, the argument, we're still arguing the summary disposition motion. After 5 years, after a decision in the trial court, after an appeal that conclusively established what this court wished to do with that motion, we're still arguing that motion which had already been decided. I believe it was, Your Honor, Counsel Judge Godola, believe you referenced law of the case, which is absolutely applicable here. The only way that the appellee can prevail on this case is if this court finds, as Mr. Frank indicated, that the language regarding the competitive interest was unenforceable dicta. Now, that hasn't been necessarily briefed at length. It was never briefed at the trial court. And that's the only way that Mr. Frank can hope to get some relief here. That You only have to look, Judge Barry, at certain portions of the opinion, but you have to disregard other portions of the opinion because they're unfavorable to me, or as all of us lawyers know, unfavorable information is unenforceable dicta. We disagree with it, so it must be unenforceable. But that's not the law of the case, and that's not the mandate rule, Your Honors.
What's the purpose of the remand? I mean, if you're right and we were to reverse Judge Barry, what would happen at that point in your judgment? You seem to be arguing that the case is over at that point. That can't be right either.
That is not right. And actually, as Judge Murray indicated, there's still challenges that can be brought to a non-compete in both scope and duration. They were not foreclosed from challenging this non-compete. This court did not waive or prevent any argument to that effect. If this court had wanted to do that, this court could have reversed and entered judgment in favor of Brooklyn Outdoor, which of course it didn't do. So, Your Honor, this panel in a prior case made a statement that caught my attention. This court indicated that we will not upset a previous ruling by the Court of Appeals. Now, that issue is resolved. And in our case, that issue is also resolved. Again, there's been no motion for reconsideration. There's been no petition for the Michigan Supreme Court. There hasn't even been an attempt to challenge the conclusive findings of this court, and those findings are binding. Counsel's making the statement that they're unenforceable dicta is not only self-serving, but it's not supported by anything in any record. And there was no analysis done. I'll also indicate that Judge Barry's determination of this issue came after, and I'm going to read you what she said. The summary disposition motions that have been filed 5 years earlier. She said, at the time the arguments were taking place, plaintiff failed to file a response, and Judge Groner failed to respond to your argument. That was inaccurate. Of course, we filed a response. There was about one paragraph in the the defendant's motion that apparently we had not addressed one particular paragraph in a roughly 25-page motion, but Judge Barry was under the impression that no response whatsoever had been filed. That really just highlights the fact that she hadn't reviewed the record. I don't want to say thoroughly, I'll say at all. There had been no review of the prior case. She just took Mr. Frank's argument at face value. Now, Mr. Frank made an argument to this panel just now that the first breach doctrine, which by the way, has already been decided, and it was already both briefed, pled, and argued both at trial court and in front of this court, it's a dead issue. But if the court wants to address it, let me just clarify. Mr. Frank's statements were misleading in the sense that there was two different contracts. There was one contract that contained the non-compete, and there was another contract that was called the Commission's After Termination Agreement. And that bound my client. And again, it's easy to make an argument and take some dramatic license, let's just say, with the facts. Because had those contracts been presented to you in writing as opposed to oral argument, you would have seen both the contracts. The initial Court of Appeals opinion that affirmed in part the trial court's opinion that my client was responsible for the Commission After Termination Agreement. It's a different agreement than the non-compete. So counsel's argument about the first breach really talks about two different contracts, and he simply fails to address that. Counsel is also wrong when he claims that if we have to take the previous opinion at face value, then dispositive relief would have been granted to Brooklyn Outdoor. That's also not the case. This competitive interest issue is only one small part of the entire analysis. And this court granted the trial court the ability and the obligation to conduct that analysis. It simply wasn't done.
Any other questions for counsel?
Thank you.
Thank you very much. I do want to correct myself on one point. I could spend a lot of time doing that, I suppose. It says has met its burden, not had met, as I said earlier. So
Correct.
just
I
to
noticed that
correct
also.
myself on that. Okay, thank you. Very, very well argued on both sides. We appreciate your arguments. The case is submitted. That brings us to the end of our 10 a.m. call. We'll take a brief recess and then come back to begin the 11 a.m. call.
All right.
All right. Good morning. I think it's still morning. Welcome to the 11 o'clock call of panel 3 in Detroit. I'll go through my spiel very briefly. We're familiar with the facts of your cases. You don't need to belabor the facts, just cut right to the most decisive legal issues. Let us know as succinctly as possible why you think you should prevail in your appeal today. In cases involving minor children or protected individuals, initials only, these arguments are being digitally recorded and will be uploaded to YouTube within the next 24 hours. So initials only in those cases. So with that, I will call our next case, which is item number 7. These are consolidated cases. Docket numbers 369-928 and 370-355. Okay, let me try. Margot Savili, Mumad Amadovich versus Goran Pekcovich. And Mr. Altus is arguing via Zoom on behalf of plaintiff happily cross defendant. So we'll give him a moment to appear. I hear someone.
Yes, I'm trying to click in, Your Honor.
Yeah, very good.
Can you hear me?
Yes, we can hear and see you. So
Okay.
we will proceed with argument from the appellant.
Thank you, Your Honor. And to be clear, we're both appellants.
True.
I'm however, unless
Yes.
opposing counsel objects, we'll go first since our.
I thought about this about a week ago and didn't think about it again, but you are correct. And I thought it was probably most appropriate to have you go first.
Right. Their interest claim depends on the judgment.
Right. Yeah. And docket 370-355, plaintiff is the appellant and vice versa in the first docket number.
Correct. Gaten Villareal on behalf of Pekcovich. May it please the court. There's no dispute here in this case that if my client had been allowed to testify in the Serbian court, that he would have testified that the only reason the debt acknowledgement was signed that they were trying to enforce in that court was because he was held hostage by an organized crime figures in Serbia and forced to sign it under threat to his family. He was never given the opportunity to offer that testimony despite his counsel asking for him to be able to testify. And the trial court here indeed found that he was denied the right to testify. And there were no apparent reasons on the record for why he was denied, no legitimate reasons for why he was denied the right to testify. And yet
He had counsel during that.
that it was his counsel who asked the court to let him testify. Mr. Petrovich, which is confusing
Right, yeah.
because Pekcovich and Petrovich.
Right.
Right.
Was he being the client at the trial in Serbia?
For most of it, for the parts where he would have testified, yes. I mean, that's the only way he could have testified would have been if he
I know,
was
but I
there.
thought there was testimony from somebody else on the other side that he was never there.
That was Mr. Amadovich's claim, that he didn't see him, that he didn't think he was ever called to testify. But the trial court disagreed with that.
And there's nothing in the appellate opinion from Serbia or in any of the other judgments, opinions that explains why he was not allowed to testify.
There's, in the Serbian appellate opinion, there's a discussion in there about him being denied the right to testify. And there's in fact 2 pages of discussion. There's never really any kind of, it seems to never go, just wash over it. And there's a talk about how, he didn't need to testify because of the documents. They had all the documents they needed, which of course goes to the whole issue. I mean, the point of the testimony was these documents are fraudulent. They were entered under coercion. He was never given an opportunity to testify to that. And if you look at Mr. Petrovich's essay deposition, he says basically that the trial court judge said, I'm not letting you testify because I don't need it. I've got the document. You signed it, so the money. By my count, that is not a legitimate reason to deny someone testimony to challenge the document that you're relying on in court. And you will, there's two different categories of defenses that touch on due process right in the Recognition Act. One of them is just, this is the court system that we just aren't going to recognize as a kangaroo court anyway, right? The other one is where in the very specific proceeding, there's a non-process, okay? And it take as a premise that you're dealing with a court that ordinarily we recognize is not a kangaroo court. It does, we wouldn't apply that first standard to it. There's got to be situations where you apply the second. And in courts where, they try to at least hold themselves out as administering justice, you would be hard pressed to find one where there's just a blatant violation because they know better. They're not going to make it explicit. Okay, you have to read between the lines, and the only way to do that is look at what was said, and the testimony we have from Mr. Pekcovich, which was undisputed, is that the judge said, "I don't want to hear from you. I have these documents, and because you signed it, the money must have been given to you." Now, I think that there was another issue here of authenticity, and I want to make a concession here about that. Okay, in reviewing this, I realized that we went astray in our initial brief. This is not an enforcement proceeding under the Enforcement Act, and that became clear when we were arguing the other side, the other case on this. But so any arguments that we made as to authenticity under the enforcement of a foreign judgment act, I'm letting go of those because this was really a common law enforcement claim. There wasn't a reference to the Enforcement of Judgments Act. So that issue's off the table as far as I'm concerned. That leaves the motion for relief from judgment, which is really where this case ought to have ended. And that's, I get, we're operating on an abuse of discretion standard there, right? That difficult standard. But it doesn't mean that decisions are unreviewable. And there are going to be instances where the decision just is outside the principled outcomes. And I would say this is that has occurred here. We don't really take issue with so much what the findings were of the trial court judge who said, well, there was a service of process, there was a service issue. Maybe there was. I'm not, even if you take at face value that the address that Mr. Amadovich's former counsel had for his client was incorrect, that's not Mr. Pekcovich's fault. So why are we setting aside a judgment in Mr. Pekcovich's favor to cure a failure on the part of Mr. Amadovich and his prior counsel to communicate? Now that counsel withdrew about 4 months after the claim of the complaint was filed. And then 3 more months went by before a summary disposition motion was filed. And then an amended one was filed in the next month. Now, the claim was made, well, I didn't get any of these. And yet it was the counsel, it was a Serbian counsel who sent him an email saying, this is your last warning, okay, that motivated him to apparently book a flight and come, but not take the steps that were necessary to preserve his response. And if you look at, and I don't think we flushed this out well in our brief, so I want to make this clear. If you look at Exhibit D to their motion for relief from judgment, it's got a packet of translated documents. And you look at when those documents were translated, you'll see it was December 26, 2019, which is 7 days before his response was due to the summary disposition motion. If you don't know that you're supposed to be litigating something, why are you preparing these translations and then using those to rely on to get relief from the judgment? So I seriously question that he really didn't know or didn't have the submitted stuff, especially when not only did his former counsel mail it to the address he was given by Mr. Amadovich, but he also emailed it at the same time to his Serbian counsel, who's the one that he admits got in touch with him about this. So we would ask that the court start with reversing on the motion for judgment, because it ought not to have ever gone beyond that when all of the failures that the trial court pointed to were Mr. Amadovich's, not Mr. Pekcovich's. If the court gets past that, then it does have to address the other issues. And we would ask the court to reverse on the due process decision by the trial court judge. It doesn't make sense to say, I'm not going to recognize you denied due process because no reasons were given for not letting you testify. That's the whole point, is there were reasons, there were not legitimate ones. I think there was a bit of semantics here. At one point, counsel for Mr. Pekcovich tells the court, look, Your Honor, I'm not aware of any sanctions or any legitimate reasons why he was not aware to testify. And then if you look at the deposition of Mr. Pekcovich, you see that the only reason that was given by the trial court judge was not a legitimate reason. So
Because he already has the documents?
yeah, that he already
But I don't understand. I mean, under the statute, we don't have to apply, like what happens in Serbia doesn't have to mirror what happens in Michigan or any other state, right? I mean, that's clear from the case law.
Sure. I mean,
So
we don't.
if the reason, I don't remember reading that, but if the reason is that the judge said, I got the documents, you signed them, I don't need to hear from you, that's not that offensive to due processes. I mean, it's like almost like a summary disposition ruling.
Parole evidence rule.
Yeah, I mean, what's so outrageous, or not that outrageous is a standard, but I mean, why does that not comport with this broader standard of due process?
Well, that would suggest no one can ever claim that they were coerced into signing the documents. We're not going to recognize that as a claim then. I don't think that comports with fundamental fairness. Allow parties to come in with, I mean, what if it was forged? Are we not going to allow them to bring in testimony that was forged? There has to be an allowance for some testimony on issues that are extraneous to the contents of the document itself, that go to whether it's a legitimate document.
So if he was coming in to testify about the documents, I might be right, but if based on what he was alleging, which is I was forced into this, I had no choice but to sign it.
Right.
That's when he needed testimony.
Right. There's no other way to get that claim in. No other way. So we ask that the court reverse on that decision. Go ahead and address the other side. I assume you don't want me doing that.
I think, what, are you talking about opposing counsel's appeal on the interest? Why don't we hold off on that?
Okay.
I'll announce how I wish to proceed on that in a minute. Thank you. Any other questions for counsel at this point? Okay. All right. You'll have a chance for rebuttal and a response. Mr. Altus, before you begin, as Mr. Villareal correctly pointed out, you represent the appellant in the second docket number and the appellee in the first docket number, which is the case that was just argued. So I treat this as if it's a cross appeal, even though it isn't. They're two separate appeals that have been consolidated. So if you would respond to Mr. Villareal's argument on his appeal, and then you can go ahead at that time and argue your appeal with respect to the interest issue. Mr. Villareal can then have rebuttal on his own appeal and respond to your appeal on the interest, and then I'll give you a chance for rebuttal on your appeal. Does that make sense?
Okay, thank you very much.
Okay.
With regard to the due process argument that they're making, I think it's important to know at the outset that the exception under the act that they're relying upon is MCL 691-1134(3)(H). That exception to domestication is discretionary with the trial court. There are exceptions, for example, lack of jurisdiction, where our court would not have the option to domesticate. But under 3H, the trial court, even if it was shown that due process was lacking in some instance in this particular court for this particular case, the trial court has the discretion to domesticate anyways. In this case, the trial court specifically said in its opinion that the mere fact that Pekcovich was not permitted to testify is not enough to deny recognition of the judgment in this matter. Now, I don't read that to mean the court found that Pekcovich was not permitted to testify. What it means is whether he was or whether he wasn't, it doesn't matter. Why? Because the trial court considered other evidence having to do with this due process argument, one of which was already raised in that the defendant who lives here in the U.S. never appeared for trial. Second, because my client had appeared for trial and defendant never showed up. But you know, what is most telling here is that if their argument had any validity at all, why would they not have presented a transcript of the trial court proceedings in Serbia? Presumably, one was ordered when they took the Serbian trial court up on appeal to the Serbian appellate court. They're courts of record, just like our own. There must have been a transcript of the trial that was presented to the Serbian Court of Appeals. And even if not, Pekcovich, the attorney who represented defendant, resides in Serbia and practices in Serbia. He could have ordered the transcript and presented it, recognizing the burden of proof to demonstrate a breach of due process was on the defendant, not on us. The trial court had already ruled that we had satisfied the requirements of domestication under the Act. The sole purpose of the hearing was to test their exceptions. So they had the purpose of going, they had to go forward with their proofs. Why didn't they present a transcript of the trial court's proceeding in Serbia? I'll tell you why. Because it doesn't support their arguments. There was one instance in which the defendant requested an appearance to testify. This was acknowledged in the opinions of the appellate court and the trial court. It was after the trial was over, he asked to appear and make and give testimony as to certain set-offs. It doesn't indicate even that the defendant himself appeared. This was made through his attorney. And the court denied his request because the trial was over, just as our courts here do. You present your proofs at trial, not after trial. And they had to do with certain set-offs, which the trial court had given them the appellate court had provided anyways. So it was not necessary for him to give testimony. I do not see how this raises or rises to the level of an abuse of discretion on the part of the trial court. The trial court considered all the facts, recognized that in every instance, due process requirements were met. The defendant had a notice of the case against him. He was represented by counsel. He was entitled to present his arguments. He was afforded the right to an appeal. There was a reasoned opinion that was rendered he had every indicia of due process was given. The one thing that they're claiming is that he asked for and was not allowed to testify. And in its discretion, the trial court said that doesn't matter because we don't know why he wasn't allowed to testify. And frankly, there's questions as to the truthfulness of that statement anyways. And if it were true, they would have presented the trial transcript to show, and they didn't. That's my response to that, Your Honor.
All right, anything on your appeal with respect to the trial court's determination on the award of interest?
Yes. The Domestication Act contemplates a thumbs up or a thumbs down. The foreign judgment's either domesticated or it's not domesticated. If you get into domesticating part of it and not other parts, you're opening the door for a relitigation of issues and weighing of the equities as they may be in the case. In this instance, the judgment was recognized and it includes the post-judgment interest in accordance with Serbian law. You can't take the interest portion out of it. You can't bifurcate that judgment and say, okay, we're going to give you part of it, but not all of it. You either do one or you do other. And I don't want to repeat what's in my brief. I'll just state that the statute and the case law provides that post-judgment interest specifically on these judgments are awarded in accordance with the law of the jurisdiction in which the judgment was awarded. And there's case law in there too. Specifically, post-judgment interest will be awarded in accordance with the law of the jurisdiction in which the judgment was awarded. That's MCL 691-1176, and also the electrolytes case that was cited extensively in the briefs. So you just cannot. It's not an abuse of discretion. It's an error of law to divide that judgment and say, okay, and the trial court had indicated to us since our first summary disposition motion was granted in part, where the trial court said, okay, we're going to domesticate this judgment, but we're going to allow the defendant an opportunity to amend his affirmative defenses to raise these exemptions or exceptions to the act, which he did. Closer to trial, the court invited further motions, which we filed. The court determined further that what we're trying here is defendant's allegation of exceptions to domestication under the act. Our part of the case had already been proven. The court had already accepted it. We were not expected to present any evidence except that which would rebut their challenge to the exceptions under the statute. We did not have to present proofs as to amount. The judgment had the amount in there. It was just that the amount had to be calculated. And so we thought for purposes of an appeal or for just the convenience of getting an updated amount, we were trying to fix an amount of the interest. But that was not a subject of proof in the trial court. The interest was set. It was according to Serbian law. The amount of the judgment was set. It was according to Serbian law. Curiously, defendant's brief on appeal does not really contest the law as I have stated it. And that's why they go into questions about whether we're asking for common law relief. We were not asking for common law relief. The amount of the judgment that has been fixed or is subject to mathematical certainty. And so the fact that their brief doesn't even respond to these allegations, I think, is also telling. Your Honor, that's all I have, unless you have questions of me.
Any questions for counsel? Okay, thank you. Mr. Gerville-Riach, why don't you begin with a rebuttal and then you can respond on the second appeal related to the interest.
Yes, I agree that the the exception to domestication, and we're relying on this discretionary. But whether it's motion for relief from judgment or it's that defense, that means sound exercise of discretion. And in our current parlance, that means basically that it's principled, it's within the range of principled outcomes. And what we're arguing is that the reasons that were given by the trial court are not valid. They do not represent a sound exercise of discretion. Now, I need to correct counsel on the record and what the trial court found. And I'm going to just go right to the opinion. Sure. The evidence presented to the court does confirm that Pekcovich's attorney attempted to call Pekcovich as a witness, but the Serbian judge did not permit him to testify. That is the finding made by the trial court, and it's based on the record that was in front of it. So there's no argument that my client was not denied the right to testify. I'm hearing for the first time that this was an attempt made after trial. I'm not at all familiar with anything in the record that indicates that. I would like to know where that is because I'm not familiar with that at all. And I don't remember that being argued at any point during this. Maybe I missed it, but I do not believe that that's actually accurate. That was not mentioned in the Serbian appellate opinion that it was after trial, and that was never given as a reason why he wasn't allowed to testify. There was a argument made that we should have had a transcript prepared. Well, if they're going to argue that it was after trial, maybe they should have had the transcript prepared. Ultimately, I don't know what a transcript would have revealed about this. I am very well aware, having done appellate practice for a long time, that there are a lot of times when stuff that you think ought to be in there is not. Handling a criminal case right now where we had to settle the record regarding the matters that were happening at the bench because there was no record of it whatsoever. So whatever the reason was, as a plaintiff, we have a choice on what evidence we want to put forward in terms of prove our case. We had the testimony of the attorney who was there and present, had personal knowledge of what happened at trial. And that's what we relied on. And that testimony was undisputed.
What if it was a sanction? I mean, isn't it what the Michigan trial court said at some point that, there's a plethora of reasons that are valid for not allowing somebody to testify?
Well, if it was, wouldn't we know that?
I don't know.
I mean,
it's your burden.
Right. But we have the opinions that say he was denied the right to testify. None of them mention a sanction.
But they don't mention anything.
Well, they do. They say they had the documents and so they didn't need him to testify. That's what they say. Just like what Mr. Pekcovich argued the trial court said. I don't see that in the trial court's opinion, but I see it in the Serbian appellate opinion. It's reflected there. And Mr. Pekcovich said that was the reason that was given. So, if that's a reason, then I guess that's an error on the court to say that there's nothing in the record that there's a reason, because that's a reason, but it's not a legitimate one. It's what counsel meant.
Was it an affidavit you said it was from your client, not his lawyer, that said it was because of the documents?
No, it was the lawyer that said that.
Lawyer
Yes,
said
in
that?
the Debene essay deposition that was admitted at trial.
Okay.
Yes, it's in there. I can give you a citation.
That's all right.
Okay. To the appendix, the appendix site for that. And I think it's cited in our brief as well.
Sure it is.
And then as far as the interest determination goes, unless there's any further questions from me on principal case. If you go in with a complaint that you want to you're saying you only want to domesticate a judgment, and you ask for $1.5 million on a judgment that on its face is less than $1 million, what are you doing? You're asking for the interest on the judgment. That's what they were asking for, and they were all over the place on what exactly that interest was. And then at trial, the trial court documents in its opinion that they were given the opportunity to bring in expert. They tried to litigate the interest. They wanted to litigate it. They were allowed an opportunity to do so, and they failed. They're right. If you just are talking about domesticating a judgment and that's all you're doing, and you're not litigating the interest, then yes, after it's domesticated, you can go and enforce the interest. But if you're going to litigate the interest issue, you litigate the interest issue to conclusion. And that was litigated to conclusion in this case. They were given the opportunity to present evidence. They tried to get an economic expert's opinion in through the Debene essay deposition of my client's attorney. And the judge rejected it as hearsay, excluded it. And the only reason for getting that in is to prove interest, to get it enforced. That's what was going on. The judge was absolutely right about that.
Any questions? All right.
Thank you, Your Honor.
Thank you very much for your argument. Mr. Altus, do you have any rebuttal on your appeal?
Very quickly, Your Honor. Number one,
Interest
having to do with the litigation of interest. We were absolutely not doing that, and the pleadings do not reflect the litigation of interest either in the answers with respect to the complaint and the answer to the complaint. All throughout our motions for summary disposition, the interest was to be established as a mathematical exercise. And the trial court had indicated that themselves, indicated prior to trial at a hearing before trial. The trial court had indicated that the amount of the judgment's not at issue, the domestication of the judgment itself is not an issue. The only thing at issue for trial was testing their exceptions to the applicability of the act. And that was the only thing that was, we didn't have to appear, we didn't have to present our judgments at all. But they did. Excuse me, Your Honor, I'm battling a cold. Anyways, if I can move on. Reference was made to, they had the documents, and that was with respect to the post-judgment request for defendant to testify.
Mr. Altus,
And-
we're done with that. We're
okay.
only on your appeal on the interest. So
Okay.
this is your
Then I've
chance for
concluded.
rebuttal on that. And so that we're not going backwards.
Okay.
Okay.
Okay. I appreciate that. Then I'm finished. Thank you.
All right. Thank you very much. Appreciate your arguments. Well done. And the cases are submitted. Thank you. You bet. Okay, that brings us to item 8, docket number 375111, Lorraine Clays versus Robert D. Johnson.
Good afternoon, Your Honors. I'm Bill Cashin, appearing on behalf of Lorraine Clays, who is a plaintiff in the underlying case and the appellate here. Lorraine Clays, we commenced a land contract foreclosure action in the Huron District Court against her stepnephew, her brother's stepson, Robert Johnson, and against the parents' trust, because the Johnsons were vendees under a land contract. Why was the trust included as a party in that lawsuit? They weren't a vendor or a vendee under the land contract. The reason is because this case presents something that I've never seen in my almost 40 years now of practicing law. That one party owns a land contract separate from a different party owning the underlying real estate that's being sold under that land contract. But that's what we have. I've also never seen land contracts where it describes the vendors as joint with rights of survivorship. But that's what we have. Bernard and Therese Clays, the parents wanted Lorraine Clays to have these 3 land contracts. So they listed her on the land contracts, joint with rights of survivorship. They died, and her brother Tom, the only beneficiaries, equal beneficiaries. Co-trustees, co-PRs fought for 5 years, finally got separate counsel, and the estate started getting probated. But this land contract to the stepson was always an issue. Tom always argued, oh, it was forgiven. Oh, it's too old. Oh, they're bankrupt. We can't collect anyway. Well, he brought it to a head before the probate court and argued that she forfeited this land contract when she signed a quitclaim deed with her parents back to the parents' trust. So we went into that issue. We got Marianne Osterbeck, the attorney that did all this, and her testimony was submitted to Judge Tomlinson. And she said, well, it's all in their trust. What if the daughter died first? Then the properties would go back into the parents' name. No, I want it in the trust. That's why we're doing the trust, to avoid probate. So she did some quitclaim deeds and had the parents and Lorraine sign saying, we convey these properties that are already sold under land contract. We convey these properties to the parents' trust, just in case Lorraine dies first. And that's how she left it. So Thomas Clays argued that by signing that deed, you forfeited your land contract interest. Well, she didn't. And that's what Judge Tomlinson ruled back in 2021. Very clearly. Tom asked for reconsideration. Judge Tomlinson denied that. And he said, no, you own the land contract, but not the real estate. When it comes time to enforce, I guess the trust will have to give the deed. But you'll have to figure that out when you go to enforce the land contract. I'm ruling on whether the land contract was waived by Lorraine Clays. No, it wasn't. She owns it by survivorship. That's what happened in 21. There's still a dozen assets in this trust. There's still a few properties. So 2.5 years later, there's a settlement dividing the remaining assets in the parents' trust and estate. And there was a disagreement on what that settlement on the record was, because I argued that we didn't say Tom gets Morrow Road on the record, but Tom's attorney did, is how it turns out in the transcript. But since we own the land contract and we own half of this property because we're a 50% trust beneficiary, Judge Tomlinson said we should get Morrow Road. And he said, no, Mr. Cashin, you guys put a settlement on the record. Ms. Burkhar said he gets Morrow Road property and your client said yes. So that was the settlement. I'm not going back and changing stuff I did in 21. So that's how he left us. So we start the foreclosure action. Thomas Clays comes in, gets a new attorney, not the attorney that's familiar with the probate and everything that happened up to this point. And they come in and argue, well, you normally would. Well, if it says Tom gets the Morrow Road property, well, of course, that includes the land contract. And that's res judicata, so you can't sue. Well, number one, it's not res judicata because this is a settlement. And the settlement, as I cited under the Dare case, goes by the intent of the parties. But more importantly, if you look at the order of settlement, what does it say? It says Tom Clays gets the entire remaining land contract interest in this property on Dixie Highway, specifically. Then it says he gets, quote, the entire remaining land contract interest in this other property on Main Street. He gets the entire remaining land contract interest in this other property on Point Trumbull. Now we get to our property on Morrow Road. It says he also gets the real property located on Morrow Road with the legal description. Just like it said, he also gets the real property located on Dixie Highway. So that is very clear that it doesn't give him Lorraine Clay's land contract. He got the underlying property as a distribution from the trust. And that's, you know, we still have this bifurcation between the two. So for the circuit court judge to assume that that included the land contract was the mistake. And I understand how it could be made because I've never seen this situation before. I would have said, of course, if you sell the land contract, you're selling the underlying real estate. But the way the estate planner drafted a warranty deed with the reservation that the grantors reserve the right to sell the property. I've never seen a warranty deed that reserved the right to sell the property, but that's what they did. That created that confusion. That was not the intent of the release. Lorraine had two other, for example, Tom received his land contract back in 21. Yeah, that wasn't mentioned in the settlement in 24 because it was already done and resolved. So all the settlement involved was what was left in the estate, which included the Morrow real estate, but not the land contract that Judge Tomlinson held had been severed by those goofy quitclaim deeds. So it's really a mistake. It's a miscarriage. She did not agree to give up her land contract. That was never at issue in 2024. It had already been decided. And so I believe that Circuit Court made a mistake in dismissing it on that basis because the settlement could not have included the land contract because it wasn't at issue, wasn't owned by the trust. And the settlement was a distribution of remaining assets in the trust.
Any questions,
That's clear. Any
counsel?
questions?
All right, you'll have time for a vote. Counsel?
Mark Davison appearing on behalf of the defendant and appellee Thomas Clays. Should be noted, the Johnsons were parties to the case, but weren't really involved in the disposition. But when I had my motions for summary disposition, the argument you just heard by Mr. Cashin was made at the second hearing in probate court. So this was decided on the merits. He brought up this whole thing in front of Judge Tomlinson in the probate court. Wait, Morrow Road shouldn't have been in this. That was a mistake. I don't remember saying that. Well, the transcripts which we had in our appendix proved that Morrow Road was very clearly stated in that settlement. That was going to Thomas Clays. And the overall picture also confirms that. The judge even mentioned, seems like a fair settlement because Ruskin, the property in Florida that Lorraine received, was roughly half of the value of the other assets in the estate. Judge Tomlinson also specifically ruled that the land contract was an asset of the trust because it was in there and she didn't have any right to collect any payments until after they died. So it was properly within the jurisdiction of that. So that argument about, wait, this should have been included because this land contract was made in the second hearing when they had the first hearing, an order hadn't been prepared, so they had to have another hearing for entry of the order, and they filed the objection. They were the ones who made this an issue. I suppose if they hadn't said anything and just gone ahead and had a sign, maybe they could try and come in the back door. But no, it was there. It was decided very clearly. The judge finally even ruled whatever interest she had in there went along to Tom Clays as part of this settlement. So it was very clearly ruled that he gets everything in everything that had to do with Morrow Road. It is res judicata, and the judgment of awarding the granting the motion for summary disposition should be affirmed.
I think that sums it up quite nicely. Any questions? Mr. Cashin, any rebuttal?
I did make it an issue. What I made the issue was Morrow Road property. Read every transcript. There's not one mention of the Morrow Road land contract. That was not.
I'm puzzled by this argument that you can somehow sever the land contract from the piece of property that the land contract covers. How is that? And by putting the property, doesn't the contract go with the property?
Generally, yes, unless the instrument of conveyance indicates a contrary intent. And that was Judge Tomlinson's opinion in 21. Exactly was the problem. It did separate it. That's what happened. I came back in 24 and said, Judge, if we're finally disposing this, you should give us the Morrow Road property since we own the land contract. And that's where he came in and said, no, I'm not going to do that. What he said, and this is out of their brief. And so I believe the Morrow Road, I believe all three of those land contract properties were still part of this estate, still part of this trust. And that was something we needed to account for. Property, not the land contract.
Okay.
And he did separate it because the deed said, we convey it to the trust, but we've reserved the right to sell the property which he held reserved, the land contract to the individuals. It was never owned by the trust. The reservation and the deed to the trust retained the land contract to the parents in Lorraine, which she succeeded to by survivorship.
Okay.
So when he said she gave up her interest, he meant in that real estate as a trust beneficiary. No way did anybody ever mention the land contract.
Okay, thank you very much. Appreciate your arguments. The case is submitted. Thanks for appearing here today. That brings us to item number 9, docket number 3770228, Torea Michelle Williams versus Robert Lamont Rambert. And counsel for plaintiff appellant has waived. Is Mr. O'Neill in the courtroom?
Good afternoon, your honors. I did not notice that the other side.
Give us your appearance, please.
Oh, I'm sorry. Kevin O'Neill, P number 36377, on behalf of Father Robert Rambert. I did not note until yesterday that the other side had waived. I didn't want to just be a no-show based on that without putting something on paper. So I'll be very, very brief. Rely on my brief. One of the earlier attorneys did state what the high standard in the abuse of discretion is. And we're stating that both parties had the ability to have witnesses. There's a 3-day trial and the court made the right decisions. And just because the plaintiff appellate disagrees is not good enough. They have to show abuse of discretion. They cannot. I would ask this court to affirm the decisions of the trial court.
Any questions from Mr. O'Neill?
Thank you very much.
Thank you very much for appearing. We appreciate it. That case is submitted. That brings us to item number 10. Now I'm going to struggle. Docket number 376883, in re the guardianship of Jack Olsen. Is Mr. Zamborowski present? All right. You are the only person endorsed for argument, so please give us your appearance.
My name is Gerald Zamborowski.
Could you lower that microphone, Mr. Zamborowski? Thank you.
Sure. Sorry, I'm so short.
No, that's all right.
My name is Gerald Zamborowski. I'm appearing in representation of myself in this matter. May it please the court. Good morning,
Yes.
Your Honors. This matter is very simple, too simple. You might even wonder why we're even here. I received almost 1 year. It was 1 year ago today. It's the 15th. 1 year ago today, April 15th, 2025. In the afternoon, I received a contact from my neighbor 10 houses away on the St. Clair River, who I've known for over 40 years when he came from Macomb County to St. Clair County. And I helped him purchase all the contracts regarding the marine business, construction business that he had on the St. Clair River, that he moved over and had a home there, 10 houses upriver.
Can we hear the argument on this appeal?
Yes. The issue is, I was held in contempt of court somehow by the Judge Tomlinson in probate court in St. Clair County, because a year ago today, Jack Olsen, my neighbor, my friend, my client, gave me a call saying that he had just been served with papers for an emergency hearing within 24 hours, less than 24 hours, the following day in St. Clair County Probate Court, and he just got it. And I said, what's the problem? Do you want me to read it over with you? He said, no, the problem is that I have a very important medical procedure in the hospital in Macomb County for a scan of my heart, and I'm going to be put under anesthesia, and I can't be even there under Moot or under Zoom. And so I can't be there. Can you try to adjourn it? And I said, I will certainly call the court right now and try to adjourn it. So I called, and a couple minutes later, and no answer came back. And so I said to my client, Jack, that I will go in your behalf if you wish. And you go to the medical procedure that you find is so important that he said he was waiting for several months for. Because I asked him, how long do you think it would be if, can you adjourn the medical procedure for next week? I can't adjourn the court hearing. Can you adjourn the medical procedure? He says, no, I'm told it would be, have to get back in line. It'll be months again. So I said, I'll go to the hearing. You go to the doctor. Good luck. I'll let you know how things go. When I got to the hearing on the 16th of April, right out of the cage, out of the what do they call that in the horse race? Out of the gate, the judge was asking me why my client isn't there, and I explained it, and as I had explained to his secretary on the phone the day before, and he said, well, did he ask you to file an appearance in this matter? And I said, technically, he didn't ask me to file an appearance, but he asked me to help him. He asked me to represent him. So I filed an appearance just knowing that I have to file an appearance to indicate to the court who I am and what my position is and why I'm there.
But lay people don't typically speak in those.
That's
terms.
correct.
They don't say, please go to court tomorrow and put in an appearance on my
Yes.
behalf. So I think you skipped a step. When did you first see the written petition?
The morning of the 16th, the morning of the hearing.
Morning of the hearing.
Yeah, my client was staying with his two best friends of over 50 years at their house because it was easier for them to get him up at their house, get him dressed, have breakfast and ready to go instead of going to his house, helping him do all that
You
stuff.
answered my question. So
Okay, thank you very much. So that's when I received it, but I didn't have a chance to discuss it with him. He had it. He had plenty of time to read it. And it was, I think, at 3:30 when he called me, and he was served at 1:30 according to the document, the proof of service filed with the court at the home of his two good friends, which is about 1.5 miles from my office and my home, and from his home, which is only 10 houses away from my home. But he didn't understand, or he knew he was going to that medical procedure. It was on me to do something to represent him at this hearing. So when the judge called the case, I said that I filed my appearance that morning and that I spoke to my client who asked me to help him out and be there for him. He's under anesthesia in Macomb County right now, a different county next to St. Clair County, and I'm here on his behalf. And so the judges immediately pounded me with questions, as you can see from the beginning of the transcripts. Well, then he didn't have a meeting with, and I kept saying, no, I had a meeting on the phone, not in person. I just got the documents. I just read them myself, and we're asking for an adjournment tonight. So he said, we're proceeding, and he's already got an attorney represented or attorney appointed to represent my client, which he did the day before, but that attorney didn't show up. He already, and then that day, by the end of the hearing, he appointed a guardian ad litem temporary, no, a guardian ad litem and a temporary guardian for my client, just because that's what he wanted to do. And what was the emergency? There was no evidence. There was no medical evidence. There was nothing indicating that a guardian was necessary, to my knowledge.
Don't
even
need to
now.
get into the merits of that.
Very
We're on the
good.
contempt only.
Very good. So the judge said, then I'm finding you in contempt, and I'm not having to, I'm removing you from the case. And I said, wait a second, that's not true. Wait a second. I didn't say anything, and it's not true. It's just isn't true, Judge. So he said he was going to set it for a contempt hearing at a later time. This was in April of last year, and it was set for hearing on the contempt issue, show cause hearing on July 7 of that year. On July 2nd, 5 days before, he had a hearing. Oh, no, I'm sorry. I filed the motion for a bill of particulars, I called it.
Right.
And that was set for July 7th. July 2nd, he already convicted me of the contempt.
Right.
So criminal contempt. And So when July 7 came around, he said, well, you're already convicted. So I presume that you agree that the bill of particulars that you file asking for clarification on like, what am I being on trial for is moot. I said, no, it isn't moot. It still hasn't been answered. It's not moot. I do not agree. And he just said, well, I think it's moot and therefore we're not having this hearing.
Well, he denied the motion.
He denied it. Exactly. So I'm still convicted. And according to my understanding, I've never been charged with criminal contempt before. No reason for anyone to do that. Judge Tomlinson had his own reason, apparently. And he thought he did anyway. And no time did anyone give me due process clarification as to what supposedly I actually did or said, or he thought I did or said, to charge me with criminal contempt. That was never spelled out. It was never shown what evidence there was to support that belief. There was never any findings of the court one way or the other on the issue. No findings of fact by Judge Tomlinson. And there was certainly no indication that the actions, if found at a later time or if specified at a later time, were intentional. You can't commit criminal contempt of court by accident, can you? I didn't think so. I believe the Michigan law says we can. That's all in the brief.
Mr. Zambrowski,
Yes.
I'd just tell you that in my view, I'm not speaking for my colleagues, but from my review of the record, this appeared to be a honest misunderstanding between yourself and the judge that probably never should have risen to the level of criminal contempt, but it did. I think we have a pretty good handle on what happened here. It's all in the record. The record's quite complete. It's a pretty straightforward issue.
Yes.
Is there anything else you feel compelled to let us know?
I just hope that that your honors do not remand this for proceedings properly according to the rules that the judge should have found. I just ask that this court reverse the conviction, let me practice and go on with my life.
Any questions for counsel? All right.
Thank you all very much.
Appreciate you appearing here today, and the case is submitted. All right. We'll come to item 11, consolidated cases, docket numbers 377016 and 377826. In re R.W. Alberahi Minors. I will pronounce it that, minor and minors. And counsel, you may give us your appearance and proceed under the tutelage, I presume, of Mr. Pinto here. So go ahead. This is your time to shine.
Good afternoon, Your Honors. My name is Natalie Blair on behalf of the appellant father in this case. CPS originally got involved with this family because the father took his oldest daughter to report sexual exploitation by the mother in this case of the oldest daughter when she allowed men into their home to sexually assault her and make the daughter watch these acts. This was a very serious allegation, which understandably CPS and DHHS wanted to remove the children from both parents. Instead, they kind of changed their focus when the mother brought up incidences of domestic violence in about 2 months into the investigation for the sexual exploitation allegations. And then by the adjudication trial, the entire focus was entirely on the domestic violence. There were a few short mentions of the original allegations that brought this petition and brought CPS involved with the family, but the findings of the judge or of the court at the adjudication trial were almost entirely relied upon potential evidence that was submitted at the trial about domestic violence. At the adjudication trial, the Michigan Court Rule 3.972C1 requires that the rules of evidence for civil proceedings apply at the adjudication trial, and that the evidentiary standard is the preponderance of the evidence. At the trial, both mother and father testified that there was no domestic violence between them. And DHHS did not present any admissible evidence that domestic violence did occur. The only other testimony that was presented at the trial was the testimony of the CPS supervisor, not the caseworker who worked directly with the family, but the supervisor who testified she was present for the team decision-making meeting in January, but that she was not present for all conversations that were had with this family. And the court, understandably, or the court, as it's entitled to do, found both parents entirely incredible at the trial, which it's entitled to do. However, in order to make a contrary finding, it needs to be supported by evidence that was admitted at trial, to which DHHS presented none. The court relied on the testimony about a PPO, which the actual PPO is not admitted as evidence at trial. It is not part of the record. There's like brief mentions to the PPO, so we don't know the exact grounds which the PPO was granted for which the PPO was granted. And there's some other evidence that at the trial, the mother testified that DHHS is who told her to file the PPO. We're not really sure what happened with that PPO, only that there was one that was signed on November 20th of 2024. But like I said, the actual PPO or the reasons for that the PPO was granted were not in evidence at the trial. The trial court also relied on a supposed mental health petition that was filed by the mother. The CPS supervisor testified that she saw a copy of this mental health petition, but they tried to look and locate where this may have been filed, and they could not find anything. They didn't know where she got this mental health petition from. It's also not clear exactly what the mental health petition has to do with domestic violence concerns between the parties. And the third thing that the court relied on heavily in making its determination that there was domestic violence between the parties and to adjudicate the children based on that, was the fact that the mother left the home with two of the children prior to CPS being involved. At trial, mother testified that she left the home because the parents were arguing about he was accusing her of cheating with the neighbors or something like that. The CPS supervisor had testified that mother had previously stated that it was because of domestic violence, but those allegations, it was unclear as to whether this was firsthand knowledge from the supervisor or if it was hearsay rules, which are part of the rules of evidence, which do apply at the adjudication trial. It's unclear whether the CPS supervisor was present for these conversations about whether about the mother saying that it was domestic violence, or if it was reading off of notes or talking to the caseworker who did not testify at the trial. So
the standard was preponderance of the evidence.
yes, Your Honor.
And our standard on a review is what? Of the factual findings.
Yeah, so the trial, the standard of review is clear error.
Right. So it's a harder standard to meet.
Yeah.
The deferential standard.
Yes, but I feel like here, because of the evidentiary issues, my client, Mr. Waleed Alberahi, was not presented, you're not given a chance to properly rebut or offer counter evidence to any of these things. His testimony was that there was no domestic violence, and while the trial court is entitled to make credibility determinations, their determinations have to be based on admissible evidence, of which there was none presented at this trial.
But what if the trial court just didn't believe your client? You don't need to have, you could testify right in front of me and I could say, well, for whatever reasons, your mannerisms, doesn't have to be evidence. And I could say, I don't believe you. I think the guy is lying.
It's completely fine that if they didn't believe him on the stand, but you can't just, the trial court just can't say, I don't believe you, so I'm going to rule the opposite, that I don't believe you that there was no domestic violence, so I get to say that there was domestic violence.
There was evidence you just indicated from the CPS worker that testified about what she had said before.
And there was the petition that the court had before it, which included the allegations of domestic violence.
The petition was not submitted as evidence at the adjudication trial. They didn't reference the
It's in the
petition at
record
all.
before the court.
It is in the record. At no point was there was judicial notice taken of the record in terms of making this additional finding. So we respectfully request that this court reverse and remand the trial courts taking jurisdiction of the children at the adjudication trial, just so that if there is admissible evidence that DHHS would like to present, then Mr. Alberahi would have a fair opportunity to counter this evidence at the trial level. Because as the Michigan Supreme Court has stated in Henry Sanders, while the adjudicative phase is only the first step in child protective proceedings, it is of crucial importance because the procedures used in adjudicative hearings protect the parents from the risk of erroneous deprivation of their parental rights. And we believe that is what has happened here with Mr. Alberahi. So if there are no other questions.
Any other questions for Ms. Blair? No, I don't think so. Thank you very much for your arguments. We appreciate it. I should have probably noted at the outset, you're arguing here as a law student. Can you tell us where you are in your studies now? And I'll compliment you on your argument. I thought you did a very fine job.
Yes, thank you. I'm a third-year law student at Michigan Law School.
Right.
After graduation, I'll be going to Worcester, Massachusetts to a legal aid there doing education law work.
You argued before, or is this your first time?
I actually argued in this courtroom last week, in front of a different panel for the same clinic.
Very nice job.
Thank you very much.
Yes.
Thank you very much.
In Western Massachusetts, is that what you said?
In Worcester, so
Oh,
central
Worcester.
Massachusetts, I guess.
Okay.
It's not
You're
very
gonna be
big.
doing education law?
Yes.
Like for I don't know what the right word is, or the IDEA stuff for.
Yeah, so I'll be
students?
doing special education law,
Yeah.
like representing students.
Oh, good.
As well as there's like some special laws in Massachusetts that allow schools to take children to court for various things. So I'll be representing children in those cases as well.
IEPs, I think.
Yeah,
that's
IEPs,
what we're
right,
looking
yeah,
for.
yeah.
Judge Murray's originally from Massachusetts.
I am. Yeah.
Great, yeah.
You are? I am. I was born there, but I've disavowed it.
Learn
because
something new every day.
I love our sports teams here. Anyway, you did a nice job and good luck in your future
Good
career.
luck to you.
Thank you
Good
so
luck.
much.
All right, thank you.
Your Honor.
Case is submitted. And our last item of the day, item 12, docket number 373-450, In re Michelle Johnson, will be submitted on the briefs. And with that, we are in recess until 10 a.m. tomorrow.
Right.